Litigators Lounge is a production brought to you by Hall Booth Smith. This podcast is published for the purposes of providing general information and education on topics which include those related to the law and legal issues, but the contents of this podcast do not constitute legal advice. Listening to this podcast or utilizing the information contained in it in any way does not constitute, nor does it create, an attorney-client relationship between you and Hall Booth Smith or its lawyers. The contents of this podcast should not be used as a substitute for competent legal advice from a professional attorney licensed in your jurisdiction.
Broadcasting from the studios of Business RadioX, it's time for Litigators Lounge. This show is brought to you by Hall Booth Smith, guiding clients through challenging workplace legal issues. Now, here are your hosts.
Hello, hello, hello. Thank you for tuning in to this week's episode of Litigators Lounge, where courtroom drama meets the comfort of casual chat and a cocktail. I'm Jackie Voronov, partner with Labor and Employment Group at Hall Booth Smith. Here with my wonderful co-host, Shylie Bannon. How are you today in Jacksonville, Shylie?
I'm good. It's for once, I don't think I can brag about the weather here in Jacksonville because it is 98 degrees and we are under a heat advisory until 8 p.m. So you probably are winning in Jersey.
Weather-wise? No, definitely not. We have a heat advisory also.
Oh.
Yeah. It hasn't been a great summer. It's either been sweltering or raining. There's been maybe one day where you could actually be outside, and that was the day I'm always in here. I haven't set foot outside. I'm a hater. I don't much care if the weather's good.
How has your summer been, Jackie? I know we've taken a little bit of time off from meeting up here in the lounge while we've had our summer breaks. How are you?
I'm good. Busy as always, trying to keep up with constant things being thrown our way. If it's not the FTC, it's Supreme Court rulings. If it's not Supreme Court rulings, it's trial calendars. If it's not trial calendars, it's the Olympics. If it's not the Olympics, it's something else. How about you?
Tort reform in Florida back in March of 2023 really threw a wrench in my plans this summer because we're now hitting the 18-month mark on all of those cases that were filed. Things are heating up in the courtroom as well as out on the pavement here. And I've traded in the lychee martinis for something a little bit stronger.
I thought of you yesterday because I tried out a new lychee martini at a new restaurant that I'd never been to before. And it checks all the boxes. So I have a new recommendation for you. Yes. If anybody listening to the show is ever at the Brick House in New Jersey, fantastic lychee martini, highly recommend. That is unpaid for advertising. That is sponsored.
I love it.
Fantastic.
I will come visit you and we'll go get some.
It was a quality lychee martini. Highly recommend. So if there's any listeners out there in the area, you have my support and endorsement.
So Jackie, we've talked about our summer breaks, but let's talk about what my jurisprudential crush, John Roberts, and his merry band of men and women did back in June before they went on their summer break.
Yeah, for those of our folks who've listened to the show a few times, it's widely known that you, Shylie Bannon, are a Supreme Court super fan, particularly of Chief Justice John Roberts. I did hear a rumor one time that you have a poster of him on your wall. Can you either confirm or deny?
I can neither confirm nor deny.
I also heard a rumor that you've got two cats, one named SCOTUS and one named Descent. Can you confirm or deny?
I can deny that one. My cat's name is Wednesday Cattams.
Do you know that I want to get a mini horse? And you know what I would name him if I got one?
What?
Pony Soprano.
I love that.
Isn't that a good one?
I love that. It's great.
Today's episode is definitely for you, Shylie.
I love it.
Because the Supreme Court really threw us for a loop a couple of weeks ago when they overruled the seminal case of Chevron versus Natural Resources Defense Council.
Yeah, I found out about it because I was actually in trial when that ruling was issued. And all of a sudden, all of my text messages started blowing up from people that I knew in high school asking me, oh, how do you feel about the death of Chevron? And I will tell you that I have thought about the Chevron rule so little since law school that I thought that maybe the company had gone bankrupt and I'd have to get gas somewhere else.
People asked you how you felt. They
Yeah.
were concerns for your
Yeah,
family?
and wanted to know my official legal opinion on it. So first, Jackie, why don't we talk about what was the Chevron rule? What is the death of this thing? And I think that for everybody out there needs to know, what is Chevron?
Okay. So you want me to kick it off on that one?
Sure.
Okay. So some 40 years ago, the Supreme Court articulated what's really a relatively straightforward premise for when a dispute arises between federal judges and agencies. Okay. And Chevron, the original ruling, describes the latitude that federal judges give agencies and how to interpret their statutes. So, what the Supreme Court articulated was a two-part test. First, the judges are supposed to examine the wording and context of the statute in question and see if they can discern what Congress's intent was, right? If they can, then the matter's settled. It's crystal clear. There's nothing else to do. However, if it's not clear what Congress's intent was, then the agency is obligated to follow what deference is given to the agency on what it interprets the law to stand for. Okay. And if there's two or more reasonable interpretations, a reviewing court has to defer to the agency's choice on how it interprets that law. So it's the legal equivalent of saying, when in doubt, ask your mom. And depending on what your mom says, that's the right answer.
If your mom happened to be the Department of Labor, the EEOC, or OSHA, correct?
That's exactly right, which my mother is all of them, and then some.
Absolutely.
Sorry to interrupt you.
No, it's okay. So before the end of June in 2024, with Chevron in place, we would see some ebbs and flows in terms of how much deference different courts gave. But at the end of the day, they were supposed to be following Chevron, right?
Right. So it's called Chevron deference, which basically for our listeners is if Congress has left an agency with a policy choice, the agency gets to make the call, not the courts. Back in 1984.
And now all of the law school administrative law textbook authors are salivating because they get to issue new editions of their textbooks after the decision in the Loper Bright Enterprises case was issued on June 28th of 2024, right?
Yeah, I don't know how much they're salivating as much as any time there's a Supreme Court opinion that overrules longstanding precedent. And in this case, it's 40 years worth of the Chevron opinion being good law. People are going to jump all over it. Everyone, if you read every single news headline, Chevron is gutted. The courts take another one of your rights away. The Supreme Court kicks you in the teeth yet again. It got a lot of negative press because of the fact that as the Supreme Court makeup has been shaken up in the last two terms, with leniency going towards the conservative side. And it all started with Dobbs overruling Roe versus Wade. And it's been a lot of that activity. And every time that happens, people go berserk. And Chevron, it was a landmark decision. And in the time between when it was passed in 1984 to the present, it's been cited by lower federal courts something like 18,000 times. And in Supreme Court opinions, like something like 70, 80, 90 times. So even though fundamentally it was really important, I don't think people really knew what it was or what it stood for until it became a headline. And suddenly it was, they're coming after your rights. You should all be scared.
All right. So tell us what happened in this new Loper Bright case and why everybody all of a sudden cares a lot about fishing.
Oh, right. I've always cared a lot about fishing. I don't know about you.
I like to eat fish.
You strike me as somebody who's a little obsessed with fishing.
Me?
Yeah.
Only if Justice Roberts is fishing.
Okay. Did you read the opinion? It's very, very long.
It's very, very long.
It's very long. All the concurring opinions are long. The majority opinion is long. The dissenting opinions are long. There's a lot.
I had to actually do my law school trick when I read this opinion, and I had to brief it the old-fashioned way, where I took notes and I broke it down with FIRAC.
Oh, and for those who might not know what FIRAC is, can you tell us?
Yes, you list the facts, you identify the issues, you identify what the ruling is, you identify what the analysis is, and then the conclusion that the court comes to. And I had to do that for the main opinion. I had to do it for all of the concurrences as well.
Did you do that here?
What?
Did you do that with this one?
Yeah, I did that here. I had to do that to figure out what was going on. And I'm still a little unclear what the ultimate outcome is going to be with this, because I think that there are some contradictions in this ruling.
Yeah. So Loper Bright Enterprises, here's what happened here. The owners of a New England fishing company took up a case against the federal agency, which was the National Marine Fisheries Services, who admittedly I had never heard of until this case, but they're a very real, very important federal agency. And apparently there was an act which sets certain fishing catch limits in order to prevent overfishing. And that statute requires fishing boats to have some kind of an inspector on board to monitor compliance, right?
You have obviously never watched The Deadliest Catch.
I have, which makes me wonder why people say a bad day fishing or the best day fishing. How's the expression go? A bad day fishing is better than the best day at work.
Yeah. But the
I
NMFS,
watched that show and I would disagree because I have never died in a squall going to work. So, okay, back to Loper Bright and what happened. So the fishing company has to incur the cost of that monitor on the boat. And in the Loper Bright case, that was about $700. And so the company was arguing that the NMFS had no authority to force it to pay this fee. And the district court disagreed. It reviewed the statute and it said that Congress had left the question open for the agency to decide. And applying Chevron, the district court deferred to the agency's choice that the boat owner should pay. And then a federal appeals court affirmed that, again, on the grounds that Chevron requires deference to the agency's interpretation and the agency's opinion. The plaintiffs then appealed to the Supreme Court and all chaos ensued. The Supreme Court then decided it's time for a huge change. And basically was like, your mom's advice is great and all, but we're here now and we're all grown up and we can make our own decisions. And that's where your buddy, Chief Justice John Roberts, authored a 35-page ruling rejecting Chevron and calling it what Justice Roberts, and I'm putting this in air quotes, fundamentally misguided, is what they said that was.
Relying on language from the 1946 Administrative Procedure Act.
That's how I understand it, yes.
And really, at the end, the language I think that's the most important from this ruling is Chevron is overruled. So very unambiguous, Chevron is toast. Courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority. Careful attention to the judgment of the executive branch may help inform that inquiry, but courts need not, and under the APA, the Administrative Procedures Act, may not defer to an agency interpretation of law simply because a statute is ambiguous. So no more deferring to mom.
Exactly. And I like he actually even goes, he was very clear. He said it's the responsibility of the court to decide whether the law means what the agency says it means. Those aren't my words. Those are
well, that makes sense because in every other question of statutory interpretation, if there isn't an administrative agency involved in that particular statutory scheme, the courts do interpret them and the courts do have all of the tools and they can look at legislative intent. They can look at congressional intent. They can look at the notes from committee hearings, things like that. But they don't say, oh, gee, we can't figure this out because there's no administrative agency to tell us what to do. So this really just puts this back on par with any other question of statutory interpretation or regulatory interpretation that the courts deal with, right?
Yeah, this isn't something really novel. Federal agencies face legal challenges to their rules all the time. And I read a statistic somewhere that they only really prevail about 70% of the time on those challenges. So even with the Chevron doctrine on their side, federal agency powers are far from unchecked. The courts have always had pretty broad authority to review agency action and agency interpretation. This is just monumental because now Justice Roberts and the court are saying that which we already know. He's just being really blunt about it and in your face about it, which is no, the agency doesn't get the sort of leg up where we'll defer to everything the agency says. The courts are the final arbitrator of what the statute is meant. I actually like they had one quote in Neil Gorsuch's concurring opinion where he wrote, "Today, the court places a tombstone on Chevron no one can miss."
That's the Western practicalities of Justice Gorsuch, who, hailing from the Rocky Mountain region, probably has a very vested interest in fishing.
I like that this case was about fishing, and I do find it interesting that the court decided to make it not just about fishing, but about everything. They went far with that ball. They took it from one end of the football field to the other and said, all right, they could have very easily avoided the blowback that clearly came from this and said, all right, in this context, we're not going to defer to the Marine agency. Yes, here's what our opinion is. But they didn't do that. They went and put the tombstone on Chevron and said, we are done resolving cases with a systemic bias in the government's favor in all situations. And I thought that was a really interesting play.
I agree with you. So, Jackie, did you get a bunch of phone calls from your clients after this ruling came out asking if they had to follow agency regulations anymore?
No, they didn't ask me if they have to follow regulations. I wish that clients would call me ahead of time before not following regulations. And I would tell them, please do err on the side of following all laws and being a law-abiding citizen. They didn't. It's been more of, does this seal the deal on the death of the FTC rule? And what will that mean? And for those out there who might need a little bit of context for that, back in early June, the FTC, or I'm sorry, even before June, several months ago, the FTC ruled that non-compete provisions are banned and prohibited across the board in all areas, industries, walks of life, and all existing non-competes are null and void. And you have to notify all your employers that their non-competes are non-existent, non-enforceable.
Yeah, we did a podcast on it. We did do an episode on that.
We sure did. And I wrote a couple articles about it because this FTC rule has been one of the most closely watched decisions or rulings, at least for me and those of us in the employment law circles, because of the legal challenges that are pending with this. And it's been, again, surprising rulings. People thought for sure that in the Fifth Circuit, that this would be enjoined, and it wasn't. And then they thought they had a second bite at the apple in Pennsylvania, and it would be enjoined there, and it wasn't. And so right now, that FTC rule is full speed ahead, set to go into effect on September 4. And now here's the Loper Supreme Court telling us you don't have to give deference to federal agencies and what they think they can do and what they think the statutes mean. And I'm very interested in seeing how this plays out in federal courts applying Loper, knowing they have to give no deference to the FTC, and what's going to happen. I'm definitely glued to my seat. It may be indicative of the fact that I need a life, and two things can be true at the same time.
No, I think that's a really good point, that it's not like the Loper Bright ruling changed things right away. I think we're going to see those really big changes, if they are going to come, in litigation on agency rulings as they wend their way through court. Because right now the injunctions aren't really dealing with that aspect of it. It's whether they had the rulemaking authority in the first place to issue this particular regulation. But let's say the courts say, okay, you do have the rulemaking authority to do it. Then we'll start to see the challenges on the Loper Bright. Do we give deference to this, or is this rule in and of itself legal on its face? Is that the way that we need to look at the FTC issue in particular?
I guess it depends on what the basis is for any particular judge's ruling. In Texas, for example, the judge in that case ruled that there should be an injunction and enjoined it, but she only did it for the plaintiffs. She stopped short of doing it nationally. So I don't think, at least if the FTC's appeal is successful, they'll argue that they get deference in how they interpret. So it depends on what really the basis for the ruling is.
I wonder if judges are going to maybe shy away from making their rulings on the Loper-Bright aspect of this so that they don't have to deal with it right away and rely on other bases to come to their conclusions.
Potentially, but right now, if you ask any legal scholar, I've only heard overwhelmingly paranoid and like the worst possible fears trying to materialize. There's a lot of scholars who think that ending Chevron deference will just usher in this new era that's marked by legal and administrative chaos, where judges are given unrestrained interpretive authority. And I don't know if that's just a little bit melodramatic, or maybe it's a portent for what is to come, because judges have always, there's 12th Circuit, there's a lot of federal judges on the bench, and a lot of them sway and lean a certain direction. Judges have always had wide latitude to interpret what a statute says and what the facts call for. I'm not sure that this will be necessarily the chaos that people think it's going to be, but it is going to throw a dramatic plot twist in what, is my favorite courtroom drama, for sure.
So what does this mean for our employers in terms of compliance long term?
I don't think there's a compliance, anything that people will need to do to stay compliant. What I do think that this has done is put the onus on federal agencies. I think federal agencies are in the worst position because they now have to really step up their game and make sure their interpretations are rock solid. Agencies can't just get by knowing the courts rubber stamp their actions anymore. I think this is a win for people who want to go to court to challenge agency opinions, and a blow for the federal government agencies. They've got to step up their game. And I understand the fears. The biggest fear evolving from all this is the Supreme Court has opened the door for federal judges to decide how executive branch agencies go about their daily business whenever it's ambiguous. Knowing all well that, let's be honest, statutes are frequently ambiguous, and they're purposely sometimes done that way. Sometimes they're intentionally ambiguous because Congress intended for the agency experts to fill in those blanks, especially in areas like fishing and environmental protection and occupational health and safety. They do defer to OSHA and they do defer to the EPA, which is why those statutes are worded the way they are. So I think that a lot of those statutes that previously were cases have been found in favor of agencies like the EPA and OSHA, et cetera. You now have grounds to challenge and reopen, potentially.
Well, for employers, I think that some of the topics and the regulations that are going to come up that Loper-Bright may be called into play on sooner rather than later. Obviously, the FTC non-compete agreement is at the forefront of what everybody's talking about. There was the Pregnant Workers Fairness Act that was issued by the EEOC. That one is going to probably be a big one that this applies to as well. The joint employer status proposed rule from the NLRB, the Department of Labor's regulation on the increasing the threshold for exempt employees for salary under the FLSA.
Definitely.
Any others you can think of right off the top of your head?
I think that this case is also super important in the area of healthcare regulation, because there's a lot of key laws that give federal agencies authorities to make rules, like the FDA, Medicare, Medicaid. That's a huge one. HHS, which is the Department of Health and Human Services, has long since promulgated a lot of rules in the healthcare space. And CMS is another one, Centers for Medicare and Medicaid Services. There's a lot of technical expertise that goes into administrating those laws and programs. I think that you might see a lot of impact there.
So not just from an employment perspective, but for our healthcare clients, the folks who deal with reimbursements, and who have to deal with CMS and compliance on coding and things like that, it's going to be a huge issue for them.
Absolutely. And one thing, while we're on the topic of Chevron, there's also a parallel case, which is known as the Auer agency deference, AUER. Don't know if you've heard of the Auer versus Robbins case before.
Why don't you enlighten us all?
Okay. So Chevron addresses legal challenges to an agency interpretation of precedential law. That's Chevron deference. But when an agency interprets its own rules and refers to and in return defers to its own informal guidance, that's our deference. Not our, like you and I, our. Or
AUER.
Yeah. So it's parallel and similar. So it may be the next chip to fall if that issue makes it up before the U.S. Supreme Court, because I would imagine that the same exact reasoning that Justice Roberts and the other 5 justices had would apply to the Auer deference also.
That's very interesting, and it's a good call to keep watch on that as well.
Yeah, I think that people have this fear, and I don't know where it necessarily came from, which is, there's this idea right now that's really permeating through a lot of news headlines. The Supreme Court is coming for your rights. The Supreme Court wants to make your lives miserable. And I don't get that from either the Chevron decision or even from the recent headline making decisions at all. I think that the Supreme Court has been given a lot of flack for making the right calls. And I know people disagree, but there's a reason why the Supreme Court judges have gotten where they are. They do give very well thought out opinions, and they're not meant to curtail people's rights. I just think that they're getting a bad rap.
And I think that if people actually took the time to look at the judges who ruled together on the sort of seminal cases that came out this year, they will see that it was not so many 5-4 decisions as they would have expected, or 6-3 decisions as they would have expected, that actually even our newest Justice Amy, would have ruled with the more liberal judges on many of these rulings. Justice Gorsuch does the same thing. Justice Kavanaugh has ruled with the more liberal bloc a number of times, and Justice Roberts at this point, in many ways, is considered to be the most moderate voice on the panel.
Yeah, I agree with you. I think that it's very interesting. I think that this will be the most resounding for administrations that prioritize like climate action. That matters here because there's a lot of different bills and agendas that have come down to fight climate change.
Yes.
And I think the climate change activists are going to come up against a wall with this one for sure.
I can't wait for Greta Thunberg to show up. So I just want to talk just a few minutes about a couple of other big rulings that came out of the Supreme Court this year that didn't get as much news as some of the others, like the election issue and obviously anything involving Donald Trump, but I think are important for our listeners to keep note of. So first, the Corner Post ruling actually goes hand in hand with the Loper-Bright ruling. The court held that it extended the amount of time that individuals have to file lawsuits to challenge an agency rule or regulation on its face. The old rule was that from 6 years from the issuance of a regulation, you had that amount of time to challenge the regulation. Now, litigants have 6 years from the point at which they suffer harm as a result of the federal agency action in order to sue. Ostensibly, that has very much lengthened the amount of time that an agency regulation can be challenged. And now it's going to be challenged using the Loper-Bright ruling as opposed to the Chevron ruling. The SEC versus Jarkissi case, I might be saying that wrong, but Jarkissi.
Jarkissi?
Jarkissi?
No, I don't know.
I don't know. That sounds like a very Italian way of saying it, but I don't know. Agencies cannot impose civil monetary penalties or civil penalties against individuals in internal agency hearings because it deprives them of their 7th Amendment right to a jury trial.
So what does that mean then? They can't impose penalties in like OSHA and NLRB settings?
Yeah, that potentially goes that way. So this was in the SEC context, but conceivably it's going to apply to OSHA and NLRB. And I know that you recently helped out some of the folks in my office on an OSHA matter. So I think that this is right in your wheelhouse.
That to me, when I hear that, my brain, like all the wheels in my brain start turning, especially because of the NLRB, which I've said a million times over. When I think of what gives me like the creeps and the heebie-jeebies and the Nightmare on Elm Street type of keep you up at night tremors, it's the National Labor Relations Board, because they have, out of any other agency, the power to what they call make whole, and their scope of remedies that they have assessed and forced employers to pay can be as creative as they want, and they can make you pay. And they have. And they've done things ranging from just making you whole by paying back pay to paying interest on credit card payments that were late, to paying the late fees on your mortgage if you don't get your paycheck in time. Whatever they determine is what the employee needs to be made whole. So with this SEC versus Jarkizi ruling, if that extends over to the NLRB context, which based on what you're telling me, and you're extraordinarily bright, so I take your word for it. I'll defer to you. I call that the Shylie Bannon deference.
So does my husband.
Exactly, because he's a smart man too. I would argue then that the NLRB has no right to impose these civil penalties against individuals, which they do against individual owners. They have.
I know. I think it's a sleeper hit from our SCOTUS friends.
Totally. One of these like, secret little cases, not a lot of fanfare, but I'm going to pull this little trick out of the hat.
I think that we have a lot to watch and to look forward to. And I think that we probably are going to be revisiting Loper Bright as actually more hits come up on our Westlaw searches for citations to the case. And maybe we'll do a full deep dive on our friends, the SEC versus Jarkizi.
Yeah, I'd love to see how this carries over. I'm going to definitely be keeping an eye on this one while I'm now that I no longer have to watch Steven Nederazic on the pommel horse anymore. That's over this week. So I've got time on my hands.
The Clark Kent gymnast, right?
Love him. I wanted him to win everything. Give him the gold just for being who he is.
He's from your alma mater.
I know. If he's listening, which he's probably not, but if ever comes a time where I can meet Steven Nederazic, we love you here.
To all of our listeners, thank you so much for tuning back in. If you have any questions or comments or topics that you would like us to cover, please reach out to us. And until next time, this is Shylie and Jackie signing off from the Litigators Lounge. Cheers.
Cheers, Shylie.
Thank you for joining us on Litigators Lounge. This show is brought to you by Hall Booth Smith, helping clients navigate the complexities of workplace legal issues. For more information, go to hallboothsmith.com.
Litigators Lounge is a production brought to you by Hall Booth Smith. This podcast is published for the purposes of providing general information and education on topics which include those related to the law and legal issues. But the contents of this podcast do not constitute legal advice. Listening to this podcast or utilizing the information contained in it in any way does not constitute, nor does it create, an attorney-client relationship between you and Hall Booth Smith or its lawyers. The contents of this podcast should not be used as a substitute for competent legal advice from a professional attorney licensed in your jurisdiction.